TorahCafe.com.
In a tough economy, some lawyers feel pressure to expand their practice into areas where they have little expertise or experience. Just as no patient would go to a gynecologist who decided to keep the office humming by doing a little cardiology on the side, why should lawyers be different? And apparently this is a problem in your profession. How is this handled? None of you have any experience with it, clearly.
It's a very difficult problem to identify, and therefore a very difficult problem to police. I mean, I've seen instances of lawyers taking cases that I didn't think they should be handling, and it's a direct violation of the rules of professional conduct in both New Jersey and New York to do that. But competence is not an absolute marker; it's a range, and sometimes the bar is low. So I don't know how you police that standard. I think it's the right standard to have, but I don't know how to police it, because, and I'm sure the judge has seen instances in her courtroom of lawyers who were handling things that she didn't think they were capable of handling. But but on a disciplinary basis, I don't know how you police that.
Have you seen that in your?
You see it, and a judge is always faced, if the client is right there, with the dilemma of unmasking the lawyer and making things worse, trying to support the lawyer through whatever step in the case is in the courtroom, and then getting people off the record and trying to sort things out. It's obvious right away. Usually it is the sole practitioner, and the most dangerous way to practice law nowadays, because with all the manifold responsibilities and compliance obligations and so on that lawyers have, nobody can do that by themselves. They try. There are people who started in a simpler age who have succeeded masterfully at it, but only with a real skill set of getting things done and networking. With the expansion of law to include any number of folks who really are unmentored, they will take this on. Nothing could be more tempting than the client that comes in with $5,000 as a retainer, very strongly recommended by somebody who's an aunt or an uncle or some really uninformed source, and who has a problem, and a lawyer says, well, I can figure this out, and I can get a form and I can file it. I could see that lawyer sitting in this room and saying that once he or she has 3 hours to spare with books, they can do it, right? And probably, we could have a little bit of a debate about it. That's why that's a very hard standard to really apply reasonably to probably the garden variety situation where it happens.
Law, like the rabbit, and unlike medicine, doesn't force the specialization. So all rabbis are given approximately the same certificate. Some are more qualified to do some things than other things. And this is true for lawyers as well. The alternative is to force the specialization that we encounter in the practice of medicine. For better or for worse, we've decided not to do this in the practice of law, and your license allows you to practice in every area. This is a classic example where I think that my opening remarks are right. It's virtually impossible to police this area. This is an area where an ethical good person self-polices, where you're almost inevitably tempted to cut a corner in tough economic times, and you know fully well that you can't be caught because there is no way to measure competence, and the only way you'll really be detected is in your own mind when you say to yourself with hindsight, gosh, I really shouldn't have done that. I took advantage of a client and their money. And so I think this is the kind of case where the legal system doesn't direct the standard. Every ethical lawyer herself, has to look at themselves in the mirror and say to themselves, am I doing the right thing? And we have to continuously remind ourselves as professionals that we have to obey ethical mandates even when we fully know we won't be caught. And I don't know in New Jersey, but I suspect that there are virtually no cases where lawyers are disciplined for taking matters beyond their competence, exactly reinforcing the notion that this is a self-policing area and each of us has to remind ourselves to be ethical.
There is a lot of policing going on. I mentioned the District Ethics Committee. One of the things that the federal court does is to review the decisions of the New Jersey Supreme Court in disciplinary proceedings against lawyers and decide whether or not we will impose reciprocal discipline. And that gives us, as judges, on a revolving basis, a number of cases to review. And the fact of the matter is, it's very hard to review more than 2 or 3 without really just kind of sitting there going, wow. It's like reading a lot of very sad books because the steps are so obvious along the way. And very often the first step is that case that began beyond the lawyer's expertise, and the phone calls weren't returned, and the money was put into the trust account, and the client was told, yeah, I got a good result, and interrogatories were never served, and it just piles up day after day after day. And just like the many lawyers and the many doctors and the many professionals who somehow don't pay their income taxes, and, we all go, that's impossible, and we've all represented 1 or 2. The bottom line is a lawyer doesn't know what he's doing, is in the same position. The deadlines come, and the deadlines go, and there's always tomorrow, and then we're back in that second floor in Madison where I was. So I think that beyond expertise tends to bring us into the area of discipline because of the mistakes. And I think one other thing we should add to this mix that probably is a bit of a police force, clients don't respect us as much as lawyers. Am I right about that? So we don't have the meek client sitting endlessly waiting for the brilliant lawyer to come back with a good result 2 or 3 years. It's usually 2 or 3, weeks? So that is a help.
Well, you said something that intrigued me, which is that lawyers don't specialize the way physicians specialize, but that's not true. Formally it's true, but there are people who do copyright law and people who do marital law and people who do entertainment law. Why don't you specialize? I mean, maybe is there not a part of the solution in formalizing what in fact already exists, and that certifying people, requiring to have a certain amount of knowledge and experience? Why shouldn't, if I want to get divorced, and believe me, I do. No, I years ago, and it was a fine divorce with a fine attorney, who I'm still paying. But I'm just a sap. What do I know? That when I go to someone, I respected her ability as a specialist. I was seeking her out as a specialist. It would be a good thing if I knew, if she said she practiced marital law, that accounted for something in education experience. Why don't you certify?
Well, I think there's a set of core competencies that do carry over across many areas of law. So to go the way that medicine goes and require everyone to be licensed in a certain area, I think would be a mistake. But there's no question that there are certain areas of the law that, for example, intellectual property law, you'd be crazy to try to practice if you didn't have the right background. But there are a lot of excellent generalists out there who can pick up the wide spectrum of civil and criminal matters that come and handle them based on this set of core competencies that they've learned in their career.
You haven't persuaded me at all. I love this idea. I may run for office on this idea. That's true of physicians too. That I have an internist. That's my regular doc. And for most of the things that happen to me, and some of them are pretty ugly, he's great. He can handle all of it. It's only in extreme cases, and I've been in them, when he says, "Oh, this requires the work of a specialist." Here's someone with additional training. He has all those core competencies. I think you're just bound by tradition here.
No, I think that's what a good lawyer would do.
But I want to add, I think that the legal system would be well served by this form of specialization.
Thank you. That's 2 votes.
It's not enough. We all agree that there ought to be generalists and there are core competencies, and we all agree, for example, that on an intellectual property matter you need to specialize. But the question is, would we be better served by a formal process that has board certification in IP, for example. I think New Jersey sometimes has, in matrimonial law, a formal specialization as well, where you can be certified as a matrimonial law expert. I think the legal system would be, we shouldn't abolish generalists. Right. We should not abolish generalists, and we should not say everybody must specialize, but I think the legal system would be well served by having a half a dozen board-certified specialties, which you can acquire if you wish to acquire them.
It was Judge Hayden suggested we put this to a vote. Could we have a show of hands of those in favor of adding this addition? Everyone can practice as a generalist who wants to, and if you like your current health insurance, you can keep it. But in addition, if you wish to practice in a specialized area of law, you think we should have this as formally certified. So all those in favor of this? Wow. I'm running for office and losing. All those who are actively against this. You people refuse to take a stand on anything. No wonder, people resent your lawyers. So I don't know. Yes.
I think a distinction should be made. In New Jersey, we have certified civil trial attorneys, certified criminal trial attorneys, and matrimonial. But that doesn't mean anyone else is barred from practicing in those areas. It just means if you see on the letterhead of the attorney certified civil trial attorney, you may be more confident that that person.
So much like organic food. You can put it on your label, but it doesn't. Anyone can do it.
No, but that's true in medicine as well. You don't have to be a board-certified radiologist to read X-rays, but you would be foolish to take your X-ray to somebody who's not a board-certified radiologist, although they will read them for you at a discount.
So I would be curious to know if, since so many of you seem to oppose this idea of the certification, and it seems to just be something that would inform a doofus like me. I'm the client. I know nothing. I don't know how to choose an attorney. And I think that's true of many, doofuses. I was going to say clients. So what's the rational objection to having this kind of certification? Why wouldn't that be entirely in my interest? Anyone who opposed it want to speak to that?
I'm not making an argument against specialization, but you ask why wouldn't anybody assume that that's the best thing to do? And the fact is that we all know, everyone who's practiced law knows, that those lines aren't always quite that clear. When a person walks into the office doesn't say to you, do you want the specialist in labor? Do you want the specialist in matrimonial, or whatever it is? If you're handling a typical case, there may be 4 or 5 different facets involved. You can't afford to have 5 partners in on every meeting. What the lawyer has an obligation to do, in my view, is not to undertake something that lawyer is not prepared to do. That may mean that he may spend the weekend learning what it is that one has to do in order to handle that case. But that lawyer may also recognize that there are environmental issues that are involved in this case. There may be the person who represents the cigarette company who may have ethical problems with representing the cigarette, but has a duty to represent that client. Some of these questions aren't just quite as simple as we would like to make them out. And one may even raise the question of whether or not the adversary system is inherently inconsistent in some respects with what someone would say is the ethical result in some results. If you've got a good lawyer, you get a good lawyer because he wins the most cases. That may not mean necessarily that justice in the ethical sense was necessarily accomplished. Sometimes it does. Hopefully it doesn't. I would add one other factor to that, and that is that judges, in most cases, except for the tax court perhaps, are generalists. If they weren't when they came into the court, they, by gosh, better be when they're sitting there. So it's not as simple as it's been made out to be so far.
I'm totally unpersuaded. As eloquent as you were, that it seems to me the medical model is a great one. I doubt that. That the generalist will always occupy the central position. I just want to know, as the patient or client, that when, in those minority of cases when it's necessary to call in a specialist, that the person who's called in is not someone who did what you said, who spent the weekend learning what they needed to know. If I knew my heart surgeon was doing that, I would not feel good about it. Anyone else want to point out how wrong I am about this?
I think that was a wonderful remark from the floor. And you're right, judges are generalists. And when you first go on the bench, if you've been practicing family law for 20 years, usually your first assignment is criminal. And, and you might say that's a criminal thing to do to everybody, including the judge, but that's how it works. And in asking around why that is, I was told just nationally that it's viewed as the most constructed practice. You can't fall off the bar. It's all very structured. There's not a lot of discretion. You do what you have to do. And that way you're trained to be a judge, to be your referee role, you're applying the law, you don't kind of start making things up. And so therefore you've got that complete synergy of not knowing a thing about it while you're learning how to be a judge. And you could say that's crazy, but you know what? It happens. It gets done. Litigation is litigation, whether you're doing a patent or you're doing a divorce case. And so I think there is a central core. There's something beautiful about the fact that a well-intentioned, smart lawyer can master his or her terrors, sit down with the books, think real hard, and make phone calls. Call the person who knows. That's how great generalists, I hate to pander to you, Justin, but there you are, great generalists like Justin learned it. One time a lawyer came in who was doing an admiralty case, and we were all scratching our heads going, what's this about? And I said, by the way, how did you learn that admiralty law? I've been doing it for years. And he said, I was the baby associate in a law firm right here, and an admiralty case walked in. And that was Friday afternoon, and Monday morning, I was the admiralty lawyer in the firm. A lot of us started that way, so it's not a bad thing. And I think the testing of yourself that goes into feeling that you can do it. I'm not talking about the person who can't do it. I'm talking about the person who really puts their mind to it, learns it, makes the phone call, bundles up their fears and goes in and does a good job. That's growth. And I believe that person makes the right ethical decisions when his or her back is against the wall. That's being a professional.
And that's what makes it a hard standard to police.
Yeah.
And well, I guess I would also say that law is not rocket science. It's also not medical science. So it probably is not as difficult a proposition as cardiology.